Good
You found
morning,
it?
Fred. Good morning, all. Uh, I had a full cup of coffee when I sat down 15 minutes ago. Where did my half a cup of coffee go? And you went and got a cup of coffee. How much cup of coffee do you
Only
have?
that. It's only that full.
You have three-fifths.
There you go. That's pretty good math, brother.
Ah,
10%. I got a 10% bonus over you right now.
God. Um. Anyway, for everyone, Brad is talking about and writing a letter about the current motion to try to remove President Clinton from the.
But Biden.
What did I just say, Clinton?
Yes, sir.
I said Clinton because I was just listening to a lecture on what happened to the under the Clinton and Obama administration. So it's running around in my subconscious. Sorry. Anyway,
Other prime suspects.
well, it's actually Peter Thiel's explanation of how of ignorance of economics results in uh, behaviors that are external to what we consider economics, which is a lot of this nonsense that's going on. It's quite brilliant, really, and it's a theme he's had since I think the late '80s, early '90s, um, and he's been proven correct about it. Anyway, so we're talking about this. Okay, so if you're going to try to remove Trump from the ballot,
Nope. Oh, okay.
Trump from the ballot. They say, well, let's try to remove Clinton from the ballot. Okay,
No, Biden.
God damn it. I did it again. Biden from the ballot.
Just for the clarity.
Damn it. Anyway, yeah, the one of a mistake that I make frequently is these Freudian slips I make frequently is something lawyers should not do. I apologize. I'm not a lawyer.
No, you're a judge.
I'm a yeah. Uh, and I'm speaking casually, so please forgive me. Anyway, so here's the deal. So now this is Brad showed me a letter that was said here we need to remove Biden from the ballot for these crimes, and it was largely about the border. Okay. The problem in these cases, and I'm reading from a U.S. United States Court of Appeals for the D.C. Circuit, and this is currently the state of understanding about presidential powers, um, is that you need to look if you were to remove someone from the ballot, there has to be at least an Article 2 problem and a Article 14 problem, I mean, an Amendment 14 problem may not actually be necessary.
Hmm.
In both cases, what's required is a court conviction. So let me read this to you. Blah, blah, blah. Under the Article 2 of the Constitution and the relevant Supreme Court precedents, the president must follow statutory mandates so long as there is appropriated money available and the president has no constitutional objection to the statute. In other words, he doesn't get to have an opinion. If he's got the money and it's something you must do, he must do it. All right. And realize that the early government had little money, right? I mean, money was a constant. The early government in the United States was more like running your household because you'd only have so much cash flow, right? They didn't have all this debt capacity. So, secondly, so too also the president must abide by statutory prohibitions. In other words, so he must abide by statutory mandates as well as statutory prohibition, unless the president has, again, a constitutional objection to the prohibition, right? You have to have a constitutional prohibition. If the president has a constitutional objection to statutory mandate or prohibition, he may decline to follow the law unless a final court order dictates otherwise. In other words, he has to follow it, but if the court says he doesn't have to follow, he doesn't. It's the court that decides, right? But the president, okay, but the president may not decline to follow a mandate or a prohibition simply because of policy objections. In other words, he doesn't get to have a fucking opinion. Of course, if Congress appropriates no money, blah, 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 right? The executive obviously can't carry forward, so it's not his fault. But absent lack of funds or claim of constitutionality that has not been rejected by a court order, the executive must abide by statutory mandates and prohibitions. Okay, so the president is open to impeachment, right? If he does this, but if he doesn't uphold the law, that requires Congress. Congress is political. When we get, and this is done by intent, right? They separated the court from the Congress by intent because the court has to be very specific and the Congress can say, you know, we just want this fucking guy out of here, right? They can do that. So the court, so in essence, whether you look at Trump's claim of insurrection, in other words, accusation of insurrection against Trump,
Right.
or you look at the failure of Biden to uphold the Constitution, both of these require a court conviction. And in other words, that's the criteria for decidability. We don't get an opinion. And frankly, is the Congress doesn't get an opinion on whether it's insurrection. They get an opinion on whether someone is to be impeached. So in this case, what's happening, and this is why I've written about this before, I expect the Supreme Court to let the heat dissipate and then rule on this matter. But what I expect to have happen is the success of both the Biden initiative, anti-Biden initiative by the right and the anti-Trump initiative by the left. I believe that gives the Supreme Court permission to act, in other words, the moral permission to act without pretense of bias. Because the court would have to say, yes, there was an insurrection. The court is not going to be able to find there was an insurrection. And that would kill the entire narrative of the left. The court could, however, find that Biden was failing to fulfill the Constitution. However, since the federal government is allowed to regulate immigration, there would have to be legislation in place that he was in fact violating. And I'm not sure that's true.
We're not sure, right?
So I don't believe either of these attempts has any meaning. The third question is whether the state actors in pulling someone from the ballot deprives the people of their position, because, in other words, their choice. And
Right.
I think that's what the Supreme Court would rule on. They would say, look, what's in your state is one thing. What's across all states, what's a question of concurrency is something else. The president is elected not by legislatures. He's elected by the people. And that's why we have the legislatures and the people, the legislatures and the electoral college, is to make sure that the president's elected by the people and the electoral college is the last check on some scam happening. So my view is that they're going to say that if the only criteria the state can use if the people choose to put forward a candidate for the presidency, the only standard the people can use, the state can use, is whether they've demonstrated the interest of the people. In other words, they say, well, you haven't got enough signatures. We're not going to bear the cost of putting you on the ballot, right? That's just a distraction. That's their real choice. However, if they wish to claim someone can't be on the ballot because of this crime, the crime can only be decided by the court. That's it.
Right.
That's all there is. So the Supreme Court, on the other hand, does not want to get in a position where they are called biased. And they've already done the floating Chads problem, right?
Yes.
Right? And they were correct. They deferred judgment on the question of the manipulation of the vote, right? And I still don't know how I feel about all this because they didn't want to get into it again. I think if you have this question come up about both Trump and Biden, which is why I want you and others to pursue this avenue, is so that we give the court a neutral position to decide from. In other words, we should assist the court in clarifying this matter. And then some of us, myself included, will do a friends of the court, which is, there's a name for this,
Right.
which we'll send in advisory papers. And of course, I'll send in mine, which is basically this argument, that the states have only to determine whether their populations have demonstrated their preference to have a person elected at the presidential level, and that isn't a matter for the states to decide other than whether the people have demonstrated a preference. I'm pretty sure that's how it will. If it didn't turn out that way, I would be really surprised. The court is extremely good at making very narrow decisions, because they are trying at all times. It's like, we are not going to legislate from the bench, right? Unless it's a lack of clarity in the Constitution.
Right.
If it's a lack of clarity in the legislation, we're going to decide very narrowly and throw the responsibility back where it belongs on the legislatures. But it becomes a constitutional question, and the right to abortion, of course, is a constitutional question. I mean, marriage should have been a constitutional question. That should have been not a matter. The federal government should have no opinion. And this is one of those things where I think the answer is pretty clear, and the courts will decide accordingly. But no, Trump is not. There is no law that prohibits. There is no right to procedurally prohibit the states to procedurally prohibit a presidential candidate from a state ballot system. There are just, as far as I know, that doesn't exist.
Because it's a federal election.
Yeah, I wouldn't even be that imprecise. I would say the people get to choose the president, and the state only gets to determine if the state's people have given enough interest that they should add them to the ballot. That's really the matter. Whereas the members of the state's electorate and this, as well as the House and the Senate, those are choices that well, I mean, frankly, the Senate should be chosen by the legislature, but those are internal choices for representation in the federal government. That's not. I don't think you can have us. Those are decisions made as appropriate, whereas the decision to elect the president is a system-wide one, and it would be way too open to manipulation if they let this stand without a court conviction. And you know, I even have a problem with high crimes and misdemeanors, because clearly getting a blowjob from your overweight, blue-dressed Jewish intern is hardly a high crime and misdemeanor. I mean, you wouldn't be able to get any Italian president to hold office for 30 days.
Oh my. Right? Oh
Let's
my.
be serious here.
You're going over the top.
I'm sorry.
Yeah, usually limit your slurs to one ethnic group at a time.
I'm speaking in admiration, not.
I'm not arguing.
All right.
Oh my.
Oh my. Anyway, it's, we're allowed to the Italians make fun of themselves. We can join in it. It's not, but anyway, all right. God. All right, I'm gonna cut this recording off
I think that's wise.
before we continue, but maybe this will be used for some people. Excuse me. This may help clarify the matter for some people. Anyway,
That's right.
thank you, Dr. Brett, for helping with this, this particular issue. Oh,
Wait,
like, go do your
yeah,
thing.
hit like and subscribe and notifications because you want to hear more of this craziness coming out.
Thank you.